Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. I am a little hoarse. Don't worry, it's nothing crazy. I just get allergies this time of year. Probably now a little bit exacerbated by all the ash in the air. We are staying indoors. We do have a HEPA filter going. And thank you so much for everyone expressed concern. Who's in the house? Hold on. Renee in Indiana, Paul in the Great Northwest, Guy in Ohio, Nancy in North Carolina, Shandora in the Bronx, Joe in the Inland Empire, Melissa in Great Neck, Lorraine in Texas, Lucy in Minnesota, Bill in Mid-Missouri, Yosef in New Jersey, Larry in Queens, Frank in San Pedro, James in Indianapolis, Ilanit in Silver Spring, Marjorie in Georgia, Alan in New York City, Sam in Virginia, Lionel's in the house in New York. Welcome, everybody. Another awesome page here in Tractate Sanhedrin. Today we're opening... Wow. Nina, if you get a chance, please bring me a glass of water. Another amazing page. This is Mishna number 1 of chapter 3 on page 23a of, now it's getting hot in here, on page 23a of Tractate Sanhedrin, the 24th volume of the Talmud. I'm going to release a video just a little later tonight, but I just want to mention it to you guys because it's so important. People are still in harm's way. I mean, there's so much devastation here. It's crazy. I know people who have lost their homes. I heard an awful story today about a family that lost their home in Pacific Palisades, and they would have gone to the wife's parents' house, except they lost their home in Pasadena. I mean, just terrible, terrible stories. And the fires are still burning. A lot of people are asking what... Thank you so much, sweetie. A lot of people are asking what you can do. What can they do? What can you do? So the Biala Rebbe says that right now is a time for careful observance of Shabbos. As it says, Exodus 35:3, you shall not light a fire in your dwellings on the Sabbath day. So right now, enhanced safety if people keep Shabbos carefully. Obviously, that would apply to people here directly in harm's way, but because we are all one family, we're all the descendants of Abraham, Isaac, and Jacob, Sarah, Rebecca, Rachel, and Leah, if you keep Shabbos carefully where you are, then we are all safer everywhere. So this is if you've been thinking about, becoming a little bit more Shabbos observant. If you haven't been keeping Shabbos, you've been thinking, maybe I could keep Shabbos. This is a Shabbos that it would be great to keep this week. From Friday evening till Saturday night, keep Shabbos. Turn off the screens, cook in advance, light Shabbos candles, connect with your loved ones, with your soul, with your Creator. And if you're not Jewish, please pray that every Jew finds his or her way back to Torah, because the whole world is safer when we stand our post. And in the merit of that, may all of you be blessed in all your worthy endeavors, and with health and safety and joy and love and meaning and prosperity and every good thing. We say Amen. Okay. Mishnah number 1 here in chapter 3, Tractate Sanhedrin, page 23. Cases of monetary law are adjudicated by 3. We learned that in chapter 1. Now, how do we choose the 3 who will serve on this rabbinic court to adjudicate a monetary case, a civil case? It really got hot in here. It's always a little warmer when the light goes on. Okay. So they're adjudicated by three, and they are chosen in the following manner. This litigant chooses one for himself, and that litigant chooses one for himself, and the two of them choose one more for themselves. This is the statement of Rabbi Meir. And the rabbis say the two judges that were chosen by the litigants choose one more judge for themselves. So this litigant can disqualify the judge chosen by that litigant, and that litigant can disqualify the judge chosen by this litigant. This is the statement of Rabbi Meir. Again, a minority opinion. And the rabbis say, the majority who overrule Rabbi Meir, when can one of the litigants disqualify the judges? Only when he brings evidence about them that they are related to one of the litigants, conflict of interest, or to each other, or that they are disqualified from serving as judges for another reason. But if they are fit to serve as judges, or they are experts ordained by the court, he cannot disqualify them. This litigant can disqualify the witnesses of that litigant, and that litigant can disqualify the witnesses of this litigant. This is the statement of Rabbi Meir. And the rabbis say, when can one litigant disqualify the witnesses of the other litigant? Only when he brings evidence about them that they are related to one of the litigants or to each other, or that they are disqualified from bearing witness for some other reason. But if they are fit to serve as witnesses, then neither litigant can disqualify the witnesses of the other litigant. That's Mishnah number 1. Now the Gemara. The Gemara assumes that the statement, this litigant chooses one, and that litigant chooses one, and the two of them choose one more, means that each litigant chooses a court of 3 judges, and the 2 courts together choose one more court. And this would be a total of 9 judges, right? Normally a rabbinic court is 3 judges. So if we're saying that the plaintiff chooses a court of 3 judges, and the defendant chooses a court of 3 judges, and then they come together, and then they choose an additional court among the judges, and so now there's going to be 9 judges on this civil trial? Can't be. But why? For what purpose does this litigant choose one court for himself and that litigant choose one court for himself? Isn't it sufficient to judge the case with 3 judges? So this is what the Mishnah is saying. In a case where this litigant chooses one court for himself, i.e. he requests to be judged before a particular rabbinic court of 3 judges, and that litigant chooses another court of 3 judges where he would like to go to have the trial, as he does not wish to be judged before the court that the first litigant requested. In this case, both of them choose one more court for themselves, i.e. they must reach a compromise and decide about the composition of the court that will judge them. The Gemara asks, and can even a debtor, somebody who owes money, restrict the choice of the court? But doesn't Rabbi Lazar say, the sages taught, that only a creditor can refuse a court chosen by the debtor due to his desire to be judged by a prominent court, but that as for a debtor, they compel him to appear in the court that presides in his own city? And the Gemara answers, it is, as Rabbi Yochanan says, concerning a different matter, that the sages taught that other matter with regard to the layman's courts known as Be'arkaot in Syria, right, where they had fewer expert judges and ordained judges. Ordained, right, remember, is a much higher level of rabbi, one of the sages, in other words. But apparently in Syria, they didn't have access to so many qualified courts, so they would, use what they had. So you could call them local rabbis or even laymen. And so they weren't so expert in the halacha and in the Torah law that would be used. And there you could object. These guys they're not qualified. There you can object. You can't go there. But where the judges are qualified, then you can't object. So here too, the sages taught the law in the Mishnah with regard to those layman's courts in Syria, which allow even the debtor to refuse to be judged before the court chosen by the creditor, claiming that they are not worthy judges. But If the creditor chooses a court of experts, people who are expert in the law, then the debtor does not have the right to refuse to be judged before them. Rav Papa said, you may even say that the Mishna is referring to courts of experts in the same city, such as the courts of Rav Huna and Rav Chisda, who were ordained rabbis, right, sages, but who lived in the same city, so they each had their own court. As in that case, each litigant can say to the other, am I burdening you by requesting that you be judged by a different court? Okay, I'd like you to go before Rav Huna. Obviously, he's qualified. So you have to walk across town. So what? We learned in the Mishnah, and the rabbis say, the two judges that were chosen choose one more for themselves. That is the halakha. That's how it came out, right? So it's almost like, I think it's done even today this way for arbitration, right? That each litigant can choose one. If there's not already a court composed for them to go to, if they're going to assemble a court to hear the case, then each litigant chooses a qualified judge, and then those two judges choose a third judge. And the rabbis say the two judges that were chosen choose one more for themselves. And if it enters your mind to interpret the Mishnah, as we said before, that each litigant chooses a court of three judges, well, this statement wouldn't make sense. After each court was disqualified by one of the litigants, shall the members of both courts go and choose another court for themselves? That's the proof that it's as I just said. And furthermore, for what reason would the Mishnah state that the standard procedure for choosing judges is that this litigant chooses one court for himself and that litigant chooses one court for himself, each disqualifying the court that the other chose? Rather, this is what our Mishnah is saying. When this litigant chooses one judge for himself before whom he requests to be judged, and that litigant chooses one judge for himself before whom he requests to be judged, the two litigants then choose one more judge for themselves, and the case is adjudicated by these three judges. So there, it's not that the two judges choose a third judge, but that the litigants who each chose one judge would then have to compromise and they choose a third judge together. Now the Gemara asks, what is different about this procedure, i.e. that the selection of the judges is performed specifically in this manner? The sages in the West, in Eretz Yisrael, say in the name of Rabbi Zera, as a result of the fact that this litigant chooses one judge for himself and that litigant chooses one judge for himself, and the two litigants choose one more judge for themselves, the true judgment will emerge. Each litigant assumes that the judges he chose do not bear a grudge against him, and he will accept their ruling. Very nice if they could both compromise in that way, but in fact, the two judges who were chosen by the litigants choose the third judge. And we believe that still the true judgment will emerge, even though the litigants themselves, might object to this third judge. But hey, the judge that each of them chose agreed that this third judge would be the right choice for this case. The Mishnah teaches, and the rabbis say, the two judges that were chosen choose one more judge. And the Gemara suggests, let us say that Rabbi Meir and the rabbis disagree with regard to what Rav Yehuda says that Rav says. As Rav Yehuda says that Rav says, witnesses do not sign a document unless they know who is signing with them. One does not sign a document unless he recognizes that those signing with him are fit to bear witness. According to the Gemara's suggestion, Rabbi Meir does not accept that which Rav Yehuda says that Rav says. Right? Because Rabbi Meir says that the litigants would choose that third judge. And that means that the two judges they've already brought, since they don't know that third judge, there's a possibility that they're going to sit on a court, with two judges that they don't know about and can't vouch for. And if that's what Rabbi Meir is proposing, it seems that he doesn't hold by this teaching of Rav, that just as witnesses would not sign a document alongside some other witness that they can't vouch for, that they don't know to be a respectable and qualified witness, so too a judge would not agree to serve alongside another judge that they don't know to be a respectable and qualified judge. But the Gemara rejects this suggestion. No. everyone accepts that which Rav Yehuda says that Rav says. And everyone agrees with the premise that we need the consent of the first two judges for the appointment of the third. Rather, where they disagree, Rabbi Meir and the rabbis, it is about whether the consent of the litigants is necessary. Rabbi Meir holds that we need the consent of the litigants as well, that the two judges would appoint that third judge, but the litigants have to agree to him. And the rabbis hold that we need the consent of the other two judges, but we do not need the consent of the litigants, the parties to the case. Now, returning to the matter itself, what Rav Yehuda said that Rav says about witnesses, that witnesses do not sign a document unless they know who is signing with them, that was also taught in a Baraisa. And this is what the scrupulous people of Yerushalayim would do, the scrupulous people of Jerusalem. So we're saying this is not necessarily a halacha for all people to follow, but people who are machmir, right? People who are very stringent with ethics and with Torah law and just being very careful, right? A bigger fence around the Torah to make sure that all their actions would be righteous and within Torah law. So the scrupulous people of Jerusalem, they would not sign a document unless they knew who was signing with them, and they would not sit in judgment unless they knew who was sitting with them. So already we're talking about people qualified to sit in judgment, judges. And these people, right, these either sages or at least high-level rabbis, they would not join a meal unless they knew who was reclining with them. Right, so very interesting. They would not join a meal if they didn't know who else was going to be there, because they considered that it is a disgrace for a learned person to sit at a meal with an ignoramus. The Mishna teaches this litigant can disqualify the judge chosen by that litigant, and that litigant can disqualify the judge chosen by this litigant. And the Gemara asks, is it in his power to disqualify judges? How could a litigant disqualify a judge? And Rabbi Yochanan says that the sages taught this matter with regard to the layman's courts in Syria, where the judges really were, from time to time, unqualified. In those courts, each litigant could refuse to be judged by the judge that the other litigant chose. But this law is not stated with regard to a court of expert judges. And the Gemara challenges from the fact that the Mishnah teaches in the latter clause, and the rabbis say, when can one of the litigants disqualify the judges? When he brings evidence that they are related to one of the litigants, or to each other, or that they are disqualified from serving as judges for some other reason. But if they are fit to serve as judges, or they are experts in that area of law which their litigation is based on, and they are experts ordained by the court, then the litigant cannot disqualify them. And by inference, Rabbi Meir is also speaking of a court of experts when he says that one can refuse to be judged, since the rabbis are disagreeing with him and overruling him. So the Gemara answers, this is what the Mishnah is saying, but if they are fit to serve as judges, they are treated like experts ordained by the court, and he cannot disqualify them. And the Gemara suggests, come in here, a baraisa that contradicts this interpretation. The rabbis said to Rabbi Meir, it is not within a litigant's power to disqualify a judge who is accepted as an expert for the public. So apparently Rabbi Meir disagrees with the rabbis with regard to an expert judge. Rabbi Meir seems to be saying that even if somebody is considered an expert by the public and who is fit to judge cases for the public, that if the litigant has some kind of objection to that judge, obviously if it's because that judge is related to the other litigant, which would totally disqualify him, then of course the litigant can object and disqualify that judge. But if he has some other problem with the guy, like, well, we got into a fight last year over some matter involving my bamboo growing into his yard, and now he's got a grudge against me and I don't want to be judged by him. Apparently, that is not an objection that somebody could use to disqualify one of the three judges who was chosen by the other litigant. So the Gemara says, say that the Baraisa should be amended as follows. It is not within a litigant's power to disqualify a judge whom the public accepted upon themselves as an expert judge for their matters, just as the halacha is concerning the layman's courts in Syria. So the interpretation is also taught in a baraisa, which teaches a litigant can continuously disqualify the judges chosen by the other litigant forever, until the latter accepts to be judged by a court that is accepted as an expert court for the public. That's the statement of Rabbi Meir. So clearly Rabbi Meir concedes that one cannot refuse to have the judge So clearly Rabbi Meir concedes that one cannot refuse to have the case judged by an expert court. In other words, you can keep dismissing the judges that the other person brings until he brings an expert. That's a qualified expert accepted as an expert by the public. And when the other side brings that kind of a judge, then you cannot disqualify that judge. You can't object to that judge sitting on your court, even according to Rabbi Meir. And the Gemara asks, but aren't witnesses like experts in that their standing is independent of their being accepted by the litigants? And yet Rabbi Meir says this litigant can disqualify the witnesses of that litigant, and that litigant can disqualify the witnesses of this litigant. If you're saying that what Rabbi Meir was saying is you can disqualify judges only until they bring an expert, accepted by the public, okay, we can understand how that would have to do with judges. But what about witnesses? We're not here talking about expert witnesses who come just to testify on their expertise and their view of the case. That's not what witnesses are in a rabbinic court. In a rabbinic court, we're talking about witnesses who saw what happened, and there have to be two of them. So there's no expert aspect to that. Either they saw it or they didn't. And as long as they're not related to one of the litigants, they can come and testify. So since Rabbi Meir said that you can object to the other person's judges and you can object to the other person's witnesses, why would you think that when it comes to the judges, you can only object if they're not expert, but if they are expert, you cannot object, since the same language was used for witnesses, and there the idea of being an expert just doesn't even apply. And the Gemara answers, it was stated with regard to that statement of Rabbi Meir that Reish Lakish says, would a holy mouth, i.e. the mouth of Rabbi Meir, say this strange statement that a litigant can prevent a witness from testifying against him? How can you object to somebody else's witnesses? Rather, amend the text of the Mishna and teach his witness in the singular, meaning that a litigant can disqualify only a witness who testifies alone. Now, it's obvious that you can disqualify a witness, who's related to one of the litigants or to the judges, for that matter. Then you could say, no, there's forget that. I'm not sure about that. But definitely, if the witness is related to either one of the litigants, he would be disqualified. So we know that. Now he's saying, since that's so obvious, that doesn't need to be said. So on what other basis could one of the litigants object and disqualify the witness brought by the other litigant if it's a single witness? Because that's an area where Torah law is different than civil law, certainly in the United States, I imagine in most places, where under Torah law, you can only establish a matter by the testimony of two witnesses. So if the other side only has one witness, yeah, you can object and say that guy's disqualified to testify alone because he's a single witness. Now the Gemara asks, for what purpose does his single witness testify? Maybe bring the mic closer and speak a little more quietly. Okay. Let me know if I'm speaking too softly. Okay. So the Gemara asks, for what purpose does his single witness testify? If we say it is to testify about monetary matters, the merciful one already disqualifies him, as by Torah law, the testimony of only one witness is not accepted. So if it is to render the defendant liable to take an oath that he does not owe the money being claimed, in this regard, the testimony of one witness is deemed credible like two witnesses. For the Torah states that if one witness supports the monetary claim of the plaintiff, then the defendant is required to take an oath that he does not owe the money. Right? In other words, if I bring you to court and I say, hey, you owe me $100, and you say, I don't owe you anything, then I can't get anything out of you unless we go to court and I prove it. If I prove it with two witnesses, you're going to have to pay me $100. If you say, Sal, I don't owe you $100, I owe you $50, and I don't have witnesses to the contrary, since you made a partial admission, then you would have to take an oath and say, I swear that I only owe Sal $50, and then you'd only have to pay the $50 and the case would be done. Or if and this is something we haven't encountered before, that if I say you owe me $100 and I bring one witness, and the one witness says, yeah, he owes Sal $100, then you could take an oath and say, I don't owe Sal anything. And if you were willing to swear an oath to that effect, you wouldn't have to pay me and the case would be over. But if you weren't willing to take an oath, then you would have to pay me the $100. And that's what having a single witness, only in this kind of a case of a monetary debt, would create that outcome. So there is value in monetary cases, for criminal case, for flogging, anything like that. One witness would be as if there were no witnesses. But for this kind of a case, one witness would have that effect. You could still get out of it by swearing an oath. But if you weren't willing to swear the oath, you would have to pay. Now the Gemara answers, actually the purpose of the testimony is to testify about monetary matters. And no, one should not raise that challenge, as this ruling is necessary only in a case where the litigant initially accepted upon himself the single witness as equivalent to two witnesses, and afterward he retracted his agreement to accept the single witness's testimony as if it were the testimony of two witnesses. And Rabbi Meir rules that this retraction is valid, and then the testimony would not be accepted, whereas apparently the rabbis would say that if I only brought one witness and then the judges asked you, will you accept the testimony of the single witness? You don't have to say yes, but if you say, yes, I accept his testimony, like as if it was two witnesses, then you would be bound by that. Now the Gemara asks, what is this teaching us that one can retract this kind of agreement? We learn this in the following Mishna, the next Mishna we're going to encounter on page 24a. If one of the litigants says to the other, my father is trusted to adjudicate for me, right? In other words, we can both disqualify any judge who's related to one of us. But if the two litigants accept that one of the judges who is related to us will judge us, then we've accepted it, right? We waived our right to object. So if one of the litigants says to the other, my father is trusted to adjudicate for me, or your father is trusted to adjudicate for me, or three cattle herders, meaning cattlemen, right? Cowboys, who are not rabbis, who are not experts. But if for whatever reason we decide, you know what, these guys have a lot of common sense, I know they know the law of cattle, and let's accept them to judge our case, so then we would waive our right to object that we don't have expert judges, and then we would have to allow the cattle herder's verdict to stand, right? Or are we going to say that, well, okay, I accepted it, but then once they started, asking questions during the case, I realized that they're total morons, and then I want to withdraw my acceptance of them as judges, withdraw my waiver of my right to object. One opinion would be you cannot retract, you've already accepted it, and the other opinion would be you can retract. So if one of the litigants says to the other, my father's trusted to adjudicate for me, or your father's trusted to adjudicate for me, or three cattlemen who are not proficient in law are trusted to adjudicate for me, all of whom are legally disqualified from serving as judges, Rabbi Meir says that the one who made the offer can retract it. And the rabbis say that he cannot retract it. Once he accepted it, he must accept their verdict. Now we're on page 23b. And Rav Dimi, the son of Rav Nachman, son of Rav Yosef, says, this is referring to a case where the litigant accepted one of these people upon himself as one of the judges, in addition to two fit judges, qualified judges. Since the dispute between Rabbi Meir and the rabbis with regard to a litigant retracting his acceptance of someone who is generally disqualified from judging is stated in the next Mishnah, right, Mishnah number 2 here in this chapter, then why would it be listed here? It must be that this Mishnah is teaching something different than what the next Mishnah is going to teach. Well, the Gemara answers, no, we need both statements because they're not teaching the same thing. And they're both necessary. As, had the Mishnah taught this dispute only with regard to a litigant who said, my father is trusted to adjudicate for me, or your father is trusted to adjudicate for me, one might have reasoned that only in this case did the rabbi say that he cannot retract his acceptance, because my father and your father are not fit to judge our case, since the judge is related to one of us, but they could judge anybody else's case because they are qualified judges. They could judge the general public. But in a case where a litigant accepts that a single witness will bring testimony rather than a pair of witnesses, since one witness is someone who is not fit to testify by himself in anybody's case, no matter who's here in court, one might say that the rabbis would concede to Rabbi Meir that he can retract his acceptance. And therefore, it is necessary for the dispute to be stated with regard to the case in this Mishnah as well as the next Mishnah. And conversely, if the Mishnah would teach us their dispute only with regard to this case, where a litigant effectively accepted one witness as equivalent to two, one might have reasoned that specifically in this case, Rabbi Meir says that he can retract his acceptance. But in that case, where he accepted his father or the father of the other litigant as a judge, one might say that Rabbi Meir would concede to the rabbis that he cannot retract his acceptance. It is therefore necessary for the Mishnah to state both disputes. And the Gemara asks, but from the fact that in the former clause, this Mishnah teaches that one litigant can disqualify the judge in singular, chosen by the other litigant, and in the latter clause, the wording is that he can disqualify his witnesses, plural. Evidently, the Mishnah teaches this specifically with regard to a case of two witnesses. It's not that he's objecting that a single witness comes alone. He's objecting to the pair of witnesses that the other litigant is bringing. And according to Rabbi Meir, he can do that. So Rabbi Lazar said, our Mishnah is referring to a case where the other litigant, the Mishnah is referring to a case where the litigant who is objecting and another person come to disqualify the witnesses, testifying that they are disqualified from bearing witness, right? In other words, let's say that you are suing me, that I owe you $1,000, and you bring two witnesses who will testify that they saw you lend me $1,000 against what I'm claiming that you never did. So then I say, not so fast, because these two witnesses that you're bringing, I happen to know that one of them is your half-brother, that is not generally known, but is true. And I have another person who will testify with me. So we are two witnesses to say that your pair of witnesses is disqualified. Now, can I and another person combine to create a two-person testimony to show that your witnesses are disqualified? The obvious problem is I'm biased. If I can disqualify your witnesses, then you have no case against me. So I would have a strong incentive to fudge the truth or maybe even lie in order to disqualify your witnesses, right? So I can only bring witnesses about my case who are not related to either of us. How can I be one of the witnesses? I am always related to myself. So what happens? The Mishna is, according to Rabbi Lazar, the Mishna is referring to a case where the litigant and another person come to disqualify the witnesses, testifying that they are disqualified. So the Gemara asks, is it in his power, like in this case, in my power, a litigant's power, to testify that the witnesses of the other litigant are disqualified from bearing witness? His testimony is tainted by a conflict of interest. How can the court accept it? And Rav Acha, the son of Rav Ika, said the Mishnah is referring to a case where he raised a challenge against the witness's fitness to testify, which cannot be disregarded due to his conflict of interest. I mean, if I say that he's related to you, if that's true, he would be disqualified. So it can't be ignored just because I brought it up. So what are we going to do? And the Gemara asks, a challenge over which matter? If we say that he raises a challenge by testifying that the witness is guilty of theft or some other transgression, is it in his power to testify to that effect? His testimony is tainted by conflict of interest, right? If I said your witnesses are disqualified because I saw one of them steal, that's a thief, and that person is not qualified to give testimony in a court of law because he's a criminal. If it were true, he would be disqualified. If I brought two other witnesses who could prove that, your witness would be disqualified. But can I testify that I saw that guy steal? I obviously have a conflict of interest. So I would not be able to testify that I saw your witness steal at one point because of my conflict of interest. Rather, it is a challenge over a family flaw. The litigant, in this case me, testifies that the witness's lineage prevents him from testifying, as he is, for example, from a family of Canaanite slaves. He's not a Jew. And not only is he not a Jew, but he's a slave or a descendant of slaves or an escaped slave. Thank God we don't have slavery anymore. But in ancient law, that would be a disqualifying factor for a witness. Rabbi Meir holds that the litigant's testimony would be accepted, as these witnesses, the litigant and the witness who testifies with him, are testifying about the family of the witness. And the witness is disqualified indirectly. I'm not testifying that I saw him do something. I'm testifying about something that should be known by the public. And so that's called an indirect disqualification. And the litigant is therefore not disqualified from giving this testimony due to conflict of interest. But the rabbis who overrule Rabbi Meir hold that since my testimony is ultimately tainted by a conflict of interest, it would not be accepted. Forget this indirect disqualification. If me giving any kind of testimony would end up disqualifying your witness and therefore having your case dismissed, I have an insurmountable conflict of interest. When Rav Dimi came from Eretz Yisrael, he said that Rabbi Yochanan says the dispute is with regard to a case in which one of the litigants claims that there are two sets of witnesses who can testify on his behalf, and the other litigant responds that one of the sets of witnesses is disqualified. In this case, the second litigant's claim is not tainted by a conflict of interest, as there is another set of witnesses who can testify against him in any event. Okay, you're bringing not two witnesses to testify against me. You're bringing four witnesses, two pairs. I could say, well, one of your pairs of witnesses for sure is disqualified because I saw him steal, or his family lineage is from slaves, or something else. And now we're going to say, I don't have a conflict of interest because you still have two other witnesses. I'm just saying that these two are no good. Rabbi Meir maintains that the litigant cannot give this testimony, as Rabbi Meir holds that a litigant who claims in court to have a certain number of witnesses ready to testify on his behalf is required to substantiate that they exist. Therefore, there is no concern that the other set of witnesses will not be brought to court, causing that litigant to lose the case due to the disqualification of the first set. In other words, if you say you have four witnesses, okay, then you're going to bring four witnesses, and the fact that I disqualify two of them isn't really going to matter. But the rabbis who overrule Rabbi Meir hold that one is not required to substantiate the existence of witnesses that he claims to have, as the disqualification of the first pair of witnesses can cause the first litigant, you, to lose the case, the second litigant, me, is consequently unable to disqualify that first pair of witnesses because of my conflict of interest. But in a case of one set of witnesses, everyone agrees that a litigant cannot disqualify them due to conflict of interest. Rav Dimi continued, Rav Ami and Rav Asi said before Rabbi Yochanan, if there is only one pair of witnesses there, then what is the law? And the Gemara interrupts, if there is only one set of witnesses, what is the dilemma? But didn't you already say, but in a case of one pair of witnesses, everyone agrees that the other litigant cannot disqualify them. So rather, the question should be understood like this. According to Rabbi Meir, who holds that a litigant can disqualify one of the other litigant's two sets of witnesses, if the second set is ultimately found to be related to one of the litigants or to each other, or is disqualified from bearing witness for other reasons, then what is the law? Can the litigant whose witnesses were disqualified then claim that the other litigant was not capable of disqualifying the first set, as it turned out that they were the only witnesses who would be testifying against him? And Rabbi Yochanan said to them, the first pair of witnesses, i.e., the second litigant who disqualified the other litigant's first pair of witnesses, already testified. Since his testimony was valid at the time, it cannot be disqualified afterward. And some say this statement in the name of a different rabbi. Rav Ashi says the first pair of witnesses already testified. So the Gemara asks, shall we say that Rabbi Meir and the rabbis disagree with regard to the issue that is the subject of the dispute between Rebbe and Rabban Shimon ben Gamliel? I'm almost done. Questions or comments, please get them in now. As it is taught in a Baraisa, with regard to one who comes to court to be judged concerning a claim against land that is in his possession, right? I've been sitting on a piece of property. I've been farming a field for 5 years. And now you come and say, what are you doing on my land? That's not your land, Sal. That's my land. I never sold it to you. And I say, you did sell it to me. You sold it to me 5 years ago. And I've been farming it continuously ever since then. So now we're going to go to court to litigate that kind of a case. And since when we go to court, I come with two kinds of evidence. I come with a deed of purchase proving that the land is mine. And I come with the argument that I've been farming it continuously for 5 years. In fact, 3 years would have been enough to establish a chazaka, right? If I'm farming it continuously for 3 years and you never objected before that, I have presumptive ownership and you would have to prove that I don't own it. The burden of proof would be on you. And if you can't prove that I don't own it, then it's going to be hard for you to do that, then I'm going to keep the land. So I have two kinds of evidence. The deed and my presumptive ownership arising from the fact that I've been farming it continuously for 5 years. So in that case, so the Baraisa says, in that kind of a case, my claim would be judged on the basis of the deed. We would bring in the witnesses who signed the deed. They would testify, and everything would be adjudicated according to the deed. The court would examine whether or not the deed is valid. This is the statement of Rebbe. But Rabban Shimon ben Gamliel says, if I bring both a deed and the chazaka that I've been farming it continuously for 5 years, the court would judge on the basis of my continuous use of the field for 5 years, the chazaka. And we discussed this dispute asking, can Rabban Shimon ben Gamliel possibly mean that the defendant's claim is judged on the basis of only his presumptive ownership and not on the basis of the deed? i.e., would we ignore the deed? Clearly, there's no reason to ignore the deed of purchase. Rather, say that Rabban Shimon ben Gamliel means that my claim that the land is mine is judged not only on the basis of the deed, but even on the basis of the chazaka. In other words, either claim would suffice. And we maintain that Rebbe and Rabban Shimon Gamliel disagree with regard to whether or not a litigant who claims to have more than one type of evidence is required to substantiate the existence of all his evidence. If I say I have two claims, then I better be able to prove both claims. Right? If I say I have two claims that show I'm entitled to this land, and then it turns out that only one of my claims works, I only have evidence for one of them, then is that enough? Because if I only said the one claim and it was good evidence, I would have won. But I said I have two kinds of evidence. What if it turns out I don't have the evidence to support the second one? Do we just ignore that? Because I already have a good claim and evidence to support it with which I could have won if I just kept my mouth shut. Or, now that I said I have two kinds of evidence, do I need to prove both kinds of evidence? Rebbe holds that one who claims to have a deed of purchase is required to bring it to court and cannot rely on the chazaka, whereas according to Rabban Shimon ben Gamliel, he can rely on the chazaka. So apparently this dispute is parallel to the dispute between Rabbi Meir and the rabbis in our Mishna. But the Gemara says, what are you talking about? You're making a false analogy. No. According to the opinion of Rabban Shimon ben Gamliel, everyone agrees that there is no need to substantiate the existence of every type of evidence. When Rabbi Meir and the rabbis disagree in the Mishnah, it is according to the opinion of Rebbe, as Rabbi Meir holds that one is required to substantiate the existence of all these types of evidence in accordance with the opinion of Rebbe. And the rabbis could have said to you that Rebbe says that one is required to substantiate the existence of all these types of evidence only vis-a-vis a claim of chazaka, of land. If one claims that he possesses the deed of sale for his land, he cannot rely on his chazaka, as the power of his chazaka comes from the power of the deed. Mere possession without an accompanying claim of how one became the owner is disregarded. In other words, I may not have the deed, and that's why I'm relying on the chazaka. But I can't just say, yeah, I've been on this land for 5 years. Whoever it says that they want the land, that they own the land, is lying, right? When I say I've been farming the land for 5 years, I have to also say, and 5 years ago, I bought the field from so-and-so, either this other litigant or somebody else who sold it to me, but I have to be able to make an argument. Maybe I don't have the deed from that purchase, but my chazaka is based on the fact that I can tell the story of where I bought the land, right? If the truth is that I stole it, and I can't even if I can't even tell the tale of how I came into possession of the land without giving some detail that it'll be easy for the other litigant to actually bring witnesses and disprove, then my chazaka will be no good. So even if I don't have the deed itself, my chazaka, right, continuous use of the land for 3 years or more, is based on an actual legal purchase that I made at some point. But here, in the case of two sets of witnesses, since the power of these witnesses does not come from the power of the other witnesses, right? The fact that there's two pairs of witnesses, they're independent of each other, right? It's not that the truthfulness of one pair of witnesses is in any way related to the truthfulness or the perspective of the other pair of witnesses. They're independent pairs of witnesses. Since the power of these witnesses does not come from the power of the other witnesses, even Rebbe would concede that one is not required to substantiate the existence of the other set of witnesses. So the fact that I said I have 4 witnesses, doesn't mean that I have to produce all 4 witnesses. I said I have 4 witnesses, but if I only bring 2 witnesses, they will suffice as long as they testify, truthfully, that I'm entitled to this law. And then you would have to bring other arguments or other witnesses to disprove what my witnesses are saying, even if originally I said I had 4 witnesses and I only brought 2 to court. Okay. That's what I've got for us today. Let me take some questions. Sharon. Were there outcries of political prejudicial judges as there are currently in our society? In other words, would people argue that judges are disqualified because of some other political consideration, what was going on in the culture? I don't know. I mean, according to what we've learned here, even if they made that argument, it wouldn't suffice, right? We would say that we're not just talking about people who know the law. We're talking about rabbis. We're talking about people who are devoted to Torah law and that therefore are righteous people. And unless there was an actual disqualifying element, like they're related to one of the litigants, we're not going to be able to disqualify them. Having said that, we also saw, in Tractate Yoma about Yom Kippur, that there was always this suspicion, that somebody might be allied with the Sadducees in their, ongoing dispute, almost rising to the level of a civil war with the Pharisees, based on, whether or not we accept the oral tradition. Now, that was very much a political consideration because the people who were saying, the Sadducees are right, what they were really after is removing power from the rulers who backed the Pharisees. So there certainly were political considerations. I'm just not sure how that played out in halacha. Bill gave an answer to Sharon, so I'm going to move on because my voice is just dying. Lionel, expert witnesses are frequently totally biased in favor of the party that employs them. So good to hear that this relates to true eyewitnesses. How does the Talmud treat expert witnesses? Or are the judges themselves expected to be wise enough that expert witnesses are never required? So it's interesting. The judges are experts, right? They are deemed to be experts. That's why they have to know all the languages. That's why they have to know about sorcery, even though sorcery is prohibited, so that they could judge a sorcerer. Obviously, there's going to be areas of the law or areas of commercial enterprise, for example, if it's a contract dispute, where they maybe don't know everything. And I think what would happen there is not so much that a litigant would bring an expert to talk about, what goes on in that field, but the judges themselves would do that, right? We don't have lawyers in these cases. They don't have advocates. There's judges and litigants. The litigants just tell their story. Maybe they can bring witnesses with them, but the judges examine the witnesses, right? It's not that the litigants have lawyers who examine the witnesses. And I think likewise, a judge would bring, if he felt that his expertise was insufficient, he would bring an expert. And that would not, I don't know if they would get paid. They would probably just be summoned by the judge to testify about their expertise. But it's definitely different than how we understand expert witnesses. Sharon, what if it is a personal injury case and the only witnesses are the involved parties? How is that adjudicated? So that's like such a solid question that I really wish I knew the answer offhand. But we said we can't establish a matter except by the testimony of two witnesses. There are not two witnesses. Does that mean that the one who injured the other gets off? Sounds initially like, yeah, because there's no witnesses. But I think it can't possibly be left that way. So I'm going to put a pin in that question because I know we're going to come to the answer later. Renee, I have never seen a witness, expert or otherwise, excluded upon objection in current litigation. You make the objection to preserve appeal, knowing you're going to be overruled, and hope your cross-exam convinces the trier of fact that the witness is either unqualified or not credible. I've never seen a judge voluntarily recuse. There you go. That's certainly how it happens in American jurisprudence. Certainly not the same body of law, but we can see that there are related issues. Lionel, what does the Talmud say about the defendants being called as witnesses by the plaintiff? Any Fifth Amendment issues? You can't call the defendant as a witness because the defendant cannot testify against himself because he's related to himself. We've seen that before. So the Fifth Amendment is built in. It's just absolutely, you cannot testify against yourself. You can't testify against your wife. You can't testify against your parents or any close relative, and you can't testify against yourself. So the defendant cannot be a witness against himself. He just tells his story, and that's one of the factors that the judges will consider. And finally, also Lionel, hopefully they don't need unanimity of 3 judges. If a somewhat less competent judge who isn't disqualified by this process can effectively prevent an appropriate ruling, answer, they don't need unanimity. That's why we have an odd number of judges, so they can decide by a majority vote. That's what I've got for us today, and with God's help, we'll be together again tomorrow, regular Friday time in the winter, which is 11:30 a.m. Pacific. We have a fast day tomorrow, very important fast, Asara B'Tevis. So this is when the siege of Jerusalem began in the first temple, at the end of the first temple era, that ultimately resulted in the destruction of the temple by Nebuchadnezzar, that we heard about a little bit about yesterday in the book of Daniel. So this is when the siege began, and this fast is considered so important that when it lands on a Friday, we don't put it off. Normally, if a fast lands on a Friday, it would end up being scheduled on Sunday because we don't want to interfere with people's preparations for Shabbos. But this fast, which sort of set the stage for the future debacle of the destruction of the first temple, is considered so spiritually significant that the sages decreed that we don't push it off. So it's a daytime fast, a minor fast. If you get up while it's still nighttime, you can have breakfast tomorrow. And then the fast begins at the crack of dawn. If you're ever wondering about halakhic times, you should download the Accidental Talmudist app for iPhone and Android. And it includes halakhic times in your area, right, for wherever you are. What time is candle lighting on Friday? What times can you say the earliest Shema, the earliest Amida on any day, etc. And when there's a fast, it'll include the times of the fast as well. And then at the Mincha Mariv afternoon and evening service, we actually abbreviate the evening service tomorrow night so we can get home and break the fast almost as soon as Shabbos begins. Why? Because it's a transgression and it's inappropriate to fast on Shabbos. So we don't want our fast to extend into Shabbos at all. So, see you, God willing, tomorrow, 11:30 a.m. Pacific. All the best.